Hi, Lori, are you on?
I am on. It's 2 o'clock, and we are going to get started. We've got a lot of ground to cover for the next 2 hours.
Okay.
I am going to turn this over to Shayla Simmons for some introductions, and then we'll turn the presentation over to Gavin Frost. I'm sorry the beeping will continue as people start to come on, and I'm watching them online. Thank you for everything, all of our presenters. And with that, Shayla, thank you.
Thank you, Lori. Welcome, everybody. I won't take up a lot of time. We want to hear everything these distinguished experts have to share with us. So today with us on Reasonable Accommodation, we have Gavin Frost, who's a senior attorney in the Personnel Law and Civil Rights section in General Law. Horace Clark, Regional Solicitor from our Southeast region in Atlanta. Sherry Walters, who is our USGS Human Resources Employee Relations Specialist, and a wonderful resource for those of you who don't know her. Bob Garby and Kate Sawyer, both from the Office of the Secretary, who do medical reviews related to requests for reasonable accommodation. These 5 people have spent some time and effort putting this presentation together, and I think we will have a lot of rich knowledge being shared with us today. So with that, I'll turn it over to Gavin.
Thank you, Shayla. All right, you see on that first page there, I've got my contact information, and that should not be misconstrued to mean that I have done this solely on my own. This is a joint presentation by the 5 of us. However, I have agreed to prepare a roadmap, and that's what you see here in the PowerPoint presentation. There will be expertise and comments provided throughout by the other 4 individuals with whom I am presenting this information. And you'll see on that cover page that this is a discussion of reasonable accommodation issues in the DOI workplace. And this is designed not only for supervisors who may be managing individuals with disabilities, but also for individuals themselves. You might be, as a participant, a person suffering from a disability. And you may be called upon as an attorney to provide advice to clients who are working with individuals that are disabled.
Excuse me, Gavin, hold on one sec.
Sure.
This is Lori. Whoever is typing in the background, can I please ask you to put your phone on mute? Thank you.
Oh, so I wasn't supposed to be typing? Yeah, so, I mean, it's designed for you to see it from a number of different perspectives. And we think that will be useful for you as a disabled individual, as a supervisor of disabled individuals, and as an attorney providing advice to clients who have disabled individuals. Okay, so on to the policy. The DOI policy is very clear. DOI will provide reasonable accommodation for the known physical or intellectual limitations of qualified individuals, employees, or applicants with a disability, unless the accommodation would impose an undue hardship on the DOI. Let me just break that down. I know those are words. We're going to get right into illustrations or examples because I think that's most helpful. But we've got a number of words in there. We've got reasonable accommodation, and I think most people have a general sense for what that might mean, and we're going to flesh that out more fully. You have to have an individual, either an employee or an applicant, with a disability. Right? So the disability is what drives the entire process, and that's going to be defined in 3 different ways. So if an individual with a disability is either an employee or an applicant, and you know of their limitations, you must reasonably accommodate, unless that accommodation would impose an undue hardship on the DOI. And we will go through all that as well. What I think may help here is just for you to get an understanding of where the presenters are going with this. We want you to understand, first of all, that the definition, the nature of disability. From there, we move to qualified individuals with disabilities, because the disability alone does not justify a reasonable accommodation. The individual must be qualified. So disability, qualified individual with a disability. From there, yes, reasonable accommodation, we flesh that out, unless it imposes an undue hardship. If you want a greater clarification about the DOI policy, you will find that in the Civil Rights Directive number 2014 that just came out this year. It's also it's co-located with the Personnel Bulletin 1401, and we'll talk about this throughout the conversation. But there are some time frames in there, and some of the time frames for responses are not clear. There's some contradictory information. But I think if you just understand as we go through this, sooner is better than later if an individual has come to you for a reasonable accommodation, or if you need one. Expeditious action is preferred by and mandated by the EEOC. The authority that Civil Rights Directive uses is Section 501 of the Rehabilitation Act. We'll talk about that briefly. I want you to understand that so that you know where this comes from. I mean, we're attorneys, so I want to ground that in the law, and that's also found, or the authority is found in 29 CFR Part 1630, that deals with disabilities, and 29 CFR Part 1614, that's the way that EEOC processes complaints. And recognize, I mean, I know that some people have this sense, but the U.S. Supreme Court has observed that reasonable accommodation can involve preferences for an employee with a disability so that he or she can obtain the same workplace opportunities that those without disabilities automatically enjoy. So there is an element of preferential treatment. And you know, in the course of this discussion, we'll also talk about what you might be able to present to individuals. Because as you can anticipate, if you give a preference, and that's observed by others in the workplace, they may want to know why. And when we talk about that, I mean, you're prohibited from disclosing the existence of a disability. But we may give you options for presenting information to individuals who are curious about why one employee is getting a preference and others are not. Okay, illustration one. You've got an attorney suffering from leukemia. And that disability, and it will be a disability, requires and mandates extensive leave for treatment and rest. The employer grants 3 months of leave, but the attorney supervisor rates the attorney's performance as unsatisfactory. And it's very timely, I know, because we're all at that point of the fiscal year where performance evaluations are coming due. Rates the performance as unsatisfactory because the attorney failed to review a sufficient number of contracts during the evaluation. Now, let me just run back. We're talking about a policy that requires reasonable accommodation for the known physical or intellectual limitations of qualified employees or applicants with a disability, unless that accommodation would impose an undue hardship. So the first question that might arise in a circumstance like this is, well, does the attorney have a disability? And the answer to that is yes. Leukemia will constitute an impairment, and we'll get to the definition, but an impairment that substantially limits a major life activity. That form of cancer is going to substantially limit normal cell growth, blood function, circulatory function. So there's no question that will be characterized as a disability. Is the attorney qualified? By that, we'll talk about this, that means is the attorney, with or without reasonable accommodation, able to perform the essential functions of the job? Well, by design, I've left that out here. I haven't given you the exact nature of the attorney's job. I mean, you could be a litigator, you could be doing more transactional work, it could be all on the phone. But in this case, assume for the purposes of the illustration that the attorney is qualified, and by that I mean the attorney can perform, with or without reasonable accommodation, the essential functions. And then the reasonable accommodation, which is in that next question, has the employer provided? The answer is yes. The reasonable accommodation was granting the 3 months of leave. 3 months of leave because that's what the attorney characterized in this illustration as being necessary for reasonable accommodation. The problem arises in that we intend, in this illustration, to punish that employee for taking advantage of the reasonable accommodation afforded. The reasonable accommodation is provided, but because the attorney hasn't reviewed a sufficient number of contracts, the employer supervisor wants to rate the employee as unsatisfactory. And we'll talk about this. There are a number of solutions that might be presented. The EEOC, for example, in a circumstance like this would say that the supervisory attorney's actions are in violation of federal law, that could not happen. But, I mean, we could look at this in a number of different ways and say, well, what about if the sufficient number of contracts was an essential function? If the number of contracts was woven into the position description or clarified specificity in the EPAP, could that be construed as an essential function, which the attorney is not able to meet with or without reasonable accommodation? I think the EEOC in that circumstance would still say, sorry, even if it's an essential function, we go back to the preference, you can't give this attorney 9 months when you give the other attorneys 12 months to perform that same duty or those essential functions. That I think you'd have a tough time arguing that the number of contracts constitutes an essential function which cannot be dealt with through the leave. So the way the EEOC would suggest that an employer look at this is to either delay the evaluation until such time as the attorney has come back from that leave. Maybe the employer says, no, sorry, we're not going to delay the evaluation. Okay, what about an interim evaluation so that you recognize that this is not a final, it's not a delayed, but it's in recognition of the fact that there will be a final evaluation at some time in the future. Or another option would be to evaluate the attorney's performance prior to the 3 months of leave. That's another option. All of those are efforts to recognize that the attorney needed and properly was provided a reasonable accommodation, and when that attorney took advantage of it, there was no punishment as a result. Would that still then, if we provided the reasonable accommodation and did not give the unsatisfactory performance, would that satisfy the DOI's policy? Yes, says the EEOC. If the unsatisfactory performance evaluation was in the record of the attorney, the EEOC would say that is in violation of the DOI's policy. And the reason I say that is you will find a number of helpful documents from the EEOC, and one of which is accommodating or providing reasonable accommodations to attorneys with disabilities. If you were to go into the EEOC's website and pull up that fact sheet, you would see an example similar to this. So I recommend that if you are confronted yourself with a disability, or you've got an employee with a disability, or a client who's looking for advice about disabilities, that you access EEOC's website and check out some of those fact sheets. They will provide a wealth of information to you. Okay, the next illustration. An attorney has lymphedema, a chronic condition which causes lymphatic fluid to pool in the attorney's right leg. The painful swelling interferes with the attorney's ability to stand and walk more than short distances, and adversely affects the attorney's ability to commute to work. The attorney requests permission to telework 4 days a week. Oh, by the way, I don't think we said this up front, but if you have any questions at any time about any of this information, feel free to pipe up. Don't wait until the end, because it may be in the moment that you have some greater clarity about the question than you do later on. Okay, so the illustration, you've got the lymphedema, right leg problem. Attorney can't walk or stand, can't walk for long distances, so the ability to commute to work. So in an effort to resolve that problem, the attorney goes to the supervisor and says, please grant me telework 4 days per week. Now, I think that most supervisors, and I mean in the DOI, I don't know about supervisory attorneys in the solicitor's office, but most supervisors with whom I work, they're reluctant to give telework 4 days out of the week. They might give 2, maybe 3, but they want to be able to see the employee in the workplace and to manage or supervise on a face-to-face basis. But the first question that supervisor would have to ask is, does the attorney have a disability? And under these circumstances, the answer is yes. Right? That impairment, that lymphedema, and I don't worry about the label itself, but that impairment substantially limits the ability of the lymph system to function properly, and therefore it substantially limits a major life activity. So you've got a disability. Is the attorney qualified? And again, we go back to, well, I haven't given you a wealth of information about that particular attorney's job, because in order to answer that question about whether the attorney is or is not qualified, we'd have to look at the job-related qualifications, the job-related standards, the essential functions of that particular position. And although many positions, let's say attorney positions, may have similar PDs, because not each attorney performs exactly the same duties, the essential functions may change as well. And I have, again, by design, denied you that information. So it's just something that you should be thinking about. But let's assume, for the purposes of this illustration, that the attorney is qualified, can perform with or without reasonable accommodation. In this case, the reasonable accommodation is telework. For example, let's say that the primary duties of this attorney and the job that the attorney performs is conducted through telephone work with clients or review of documentation, all of which could be done outside of the physical location of the employer. Or at least an argument could be made to that effect. So in this case, the attorney, if you accept my hypothetical here, could perform the essential functions outside of the physical workplace or location of the employer, and thus would be able to perform with some reasonable accommodation in the form of telework, the essential functions of the job. Now the employer, and here's the next question, how should the employer respond to that request? Well, if this is all you have, you might have to go back to the employee, to the attorney, and say, we need additional medical information about the problems that you're experiencing, right? If you go back to the DOI policy, the limitation that this disability imposes on you, so that we can understand a little bit more clearly whether you would actually need telework for 4 days a week, or perhaps some lesser amount, or is it possible that we could, on a temporary basis, change your schedule? Is it possible that your medical provider would agree that you might be able to get by with 3 days a week, and we could trial period this for 3 months or 2 months? And that's exactly the way that EEOC would expect the employer to react. It may be appropriate to go back to the employee and ask for information, but to simply say no would be risky. You would do that at your own peril. So the solutions might be, well, if you're reluctant as a supervisor to grant the telework for 4 days, what about 2 or 3 days? Would that be satisfactory, again, given the attorney's essential functions, if the attorney was working on primarily document review and communicating with clients telephonically? That might be possible. And would it be possible to change the schedule for a temporary period, trial basis, see how this works? Now I'll throw another wrinkle in there. What about a circumstance much like this illustration, but we change it? And I've got another illustration later on that we'll talk about. But what if that attorney, on a daily basis, had to interact with colleague attorneys or with paralegals, and it had to be the type of interaction that required close work, side by side? That might not be the type of work with those essential functions that would lend itself to reasonable accommodation in the form of telework. I mean, if performance started to deteriorate because the employee was not there in the workplace, that might not be something that could be reasonably accommodated. So at least be cognizant of the fact that different types of jobs might or might not be more readily addressed through reasonable accommodation. Okay, statutory provisions. This is what we'll buzz through. This is all tied to Section 501 of the Rehabilitation Act of 1973, and it's just a poorly written statute, but it does prohibit, not explicitly, agencies, including the DOI, from engaging in disability discrimination with regard to what you see there: job applications, hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. So it's broad, and by design. That's the way that Congress wanted it. What 791 does is it requires the agency to establish an affirmative action plan. It provides the basis for complaints going to the EEOC and potentially to district courts and certain courts of appeal, and it makes standards found in other federal law applicable for the purposes of determining whether the agency has violated the Rehab Act. Here's the importation, and I know what we've been talking about thus far is the Rehabilitation Act. That is the statute that applies to federal employees. But Section 501 of the Rehab Act incorporates the standards of substantive liability found in the ADA, and that general rule states, and this is in the statute for ADA, which by importation applies, DOI shall not discriminate against a qualified individual. So you see that again. Qualified individual on the basis of disability in regard to job application procedures, hiring, advancement, discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. So we see again, got to have a qualified individual, got to have a disability in order to impact and implicate the ADA and therefore the rehabilitation. So let's construe the general rule, and this is again in statute. The term discriminate against a qualified individual on the basis of disability includes, and it's got a number of loose language, but at least one of those is not making reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee, unless the accommodation would impose an undue hardship on the operation of the business. So you've seen that in the DOI policy. It picks it up. It's not exact, but this construction of the general rule from the ADA is where we find the basis for the DOI policy. Discriminating against a qualified individual means not making reasonable accommodations. So in order to avoid that then, to comply with the general rule, we must provide reasonable accommodations for the known physical or mental limitations of an otherwise qualified individual with a disability unless there's an undue hardship. So we define disability. It's a three-part definition. But the Rehabilitation Act itself simply says the term individual with a disability means any person who has a disability as defined by the ADA. The Rehab Act, as I said, is not well developed, but it relies heavily on the ADA to flesh things out, and you'll find that at 29 U.S.C. Section 705. There are some exclusions: compulsive gambling, kleptomania, pyromania, the other ones that I've got there, and then also the gender identity issues, transsexualism, transvestism. Those would not be characterized as disabilities. But they are, however, and I call your attention, they're protected under Title VII with the Macy's. So although they're not subject to discrimination based upon a disability, they could still be the basis for a discriminatory act under Title VII, and that then the EEOC would take up under that statute and not under the ADA. But I just call your attention to the fact that some of those forms of what might be characterized as disability, compulsive gambling and kleptomania, those others, they are specifically excluded, including the psychoactive substance abuse disorders resulting from current illegal use of drugs. And the ADA definition of disability then, because that's what the Rehab Act relies upon, defines disability as follows. We've got a physical or mental impairment that substantially limits one or more major life activities. A physical or mental impairment. Number two, substantially limits. And number three, major life activities. A second form of that definition is a record of that type of impairment. And I call your attention to this. That means a record of an impairment that substantially limits one or more major life activities. The third piece here, that third prong of the definition, is different. Although it reads being regarded as having such an impairment, you might logically conclude that means an impairment that substantially limits one or more major life activities, and that would be wrong. That third prong then, being regarded as having such an impairment, means just having an impairment. If you regard an individual as being impaired, that qualifies under the definition of disability. But, and here's the big but, that portion of the disability definition does not entitle the individual to reasonable accommodation. So there's a big difference between A, B, and C. A and B, A is typically referred to as the actual disability prong. Actual disability. A, you've got a physical or mental impairment that substantially limits one or more major life activities of the individual. And B, the record of that impairment. Let me give you an example. And I've got some in here. Let's say that you've got a cancer that's in remission, or a bipolar disorder that is not substantially limited, but previously it did. The individual has that record, and let's say at a later time, after the cancer, for example, is in remission. The individual needs some follow-up, some monitoring. Well, that follow-up might be extensive, and the individual would not have to show again that he or she is at that point in time substantially limited in one or more major life activities. Instead, the individual could simply show, hey, I have a record of that type of impairment. And therefore, the individual would be entitled to a reasonable accommodation, again, as long as it does not impose an undue hardship. But that last piece, being regarded as, would not entitle the individual to reasonable accommodation. The reason that's there is Congress wanted to allow individuals who are treated in a disparate manner or subjected to a hostile work environment, right? They're punished for almost a knee-jerk reaction by an employer to an impairment. They wanted to give individuals an opportunity, a legal opportunity to address that without actually having to show that the individual is actually disabled. So that's why that's in. And again, all of this is construed in favor of very broad coverage. It's not designed to be narrow. So a physical or mental impairment, and I'm going to go through this quickly, is many, many, many things. I would venture a guess that most of us on this call have some type of physical or mental impairment because it is not designed to be restrictive. It is designed to be very, very, very broad. So as you can see there, any physiological disorder or condition, cosmetic disfigurement, anatomical loss, and affecting any of those systems, would qualify as a physical impairment. The mental aspect of it, and this gets a little bit more difficult, because sometimes the physical impairments are more readily observable, whereas the mental or psychological disorders, such as intellectual disability, formerly termed mental retardation, or the other language here that's involved in the statutory definition, they're not as readily observed by the naked eye. So that may become a little bit more difficult in the context of a disability or a request for reasonable accommodation. And supervisors have to be mindful of that. And another thing is this, is that there are in many instances, especially with that second piece, that second form of the definition, individuals are embarrassed. They don't want to disclose the existence of a mental or a psychological disorder. Well, they're fearful for a number of reasons. The individual may be fearful that people make fun of them, right? They don't want to be made fun of. And another reason that they may try to conceal that is they're fearful that the employer will take action based upon what they perceive to be the negative implications associated with a mental or psychological disorder. So be very careful when you're dealing with an individual, let's say, whose performance starts to plummet, and you may believe that there may be a mental or a psychological disorder that's affecting a mental impairment. And we'll talk about that because the individual still has rights to privacy. You simply can't go in and say, hey, I want to know what's going on. But there may be ways for you to work around that. And one of the ways that you can always deal with that is by asking the question, how can I help? There is nothing wrong with asking, how can I help? And I encourage you to keep that in the back of your mind at all times. How can I help? There may be an opportunity to provide the help. Maybe the help is rejected. Maybe the help has to be modified. But at least the effort to provide the help gets us towards or advances us towards resolving the problem, which we're all about. And again, recognize there's no implication, negative implication from the omission of any particular impairment. We want it to be broad. The impairment does not have to be active. So an impairment that intensifies and remits, let's say a reaction to chemicals or an allergic reaction to something else, something internal. That could still, when active, if it substantially limits a major life activity, that qualifies as an impairment. So don't narrow this. Keep it, understand that it's very broad. Keep it broad. So we've talked a little bit about the physical or mental impairments. Let's just talk briefly about major life activities, and they're broad again. This has been a remarkable change in the last 5 years, right? We've seen changes in the physical and mental impairment definition. We've certainly seen changes in major life activities. It used to be very quite narrow. And what used to happen is that the argument that attorneys would use, at least from the government side, was that the individual had not shown that he or she had a physical or mental impairment that substantially limited a major life activity, because the major life activities were sort of narrow. Now they're not. Now it includes many, many, many things, and you'll see them there. I've kind of highlighted and bracketed where things have changed, and I call your attention to interacting with others as a major life activity. An individual who may have an impairment or who is impaired, and that impairment substantially limits the ability to interact with others, that person is disabled. Does that automatically entitle the individual to reasonable accommodation? No. No, it does not. But it may mean that the person is disabled because he or she has a significant problem interacting with others. You'll also see there in that second paragraph, that second bullet, all of the major bodily functions that fall into the category of major life activities, or the operation of those functions, so that if a person has an impairment and it substantially limits any of these major bodily functions, that's a disability. So you probably are getting the question is, what's it mean to be substantially limited? And we'll be there in a second. But before we get there, just look at that bottom portion. The Amendments Act, the ADA Amendments Act, specifically instructs against interpreting major to create any demanding standard for disability. They do not want that. And again, the EEOC is very clear in saying this list is illustrative, not exhaustive. Don't conclude that the exclusion of something from that list means that there's not a major life activity. It still may be, and likely would be, especially for the EEOC. Okay, so we've gone through the physical and mental impairment and the major life activities. So what we need to connect those is the substantial limitation. It's not meant to be a demanding standard, and the way in which the EEOC rule has looked at this really is substantial limitation means substantial limitation, but they haven't really fleshed it out more fully than that. The impairment is a disability. It becomes a disability if it substantially limits the ability of the individual to perform that major life activity, which we just talked about, as compared to most people in the general population. An impairment need not prevent or significantly restrict the individual from performing that MLA, that major life activity. But I will say that not every impairment constitutes a disability. It just now, because of the changes in the law, is much easier for an individual. So if you've got an impairment and you believe that it substantially limits one of those major life activities, you're disabled. You're arguably disabled. What that means, though, still is we haven't gotten to the point yet where there's reasonable accommodation. It would certainly mean that you're entitled to protection from disparate treatment, from a hostile work environment, from retaliation, certainly. But reasonable accommodation, maybe not, because we've got to get to the qualified individual with a disability. But before we get there, I want to talk a little bit more about the substantial limitation, so you understand that that's the connection between the impairment, the physical or mental impairment, or intellectual impairment, and the major life activity. The determination of whether some impairment substantially limits major life activity is made without regard to mitigating measures. So you have to evaluate the effect of the impairment without any medication, without any medical supplies, without any prosthetics. So, for example, diabetes, you could not look at that impairment on the major life activity of the endocrine function by saying, well, what about the impact of the insulin? You can't do that. So all of these mitigating measures, that while they're relevant and important, not for the purpose of determining whether the individual is disabled. And the only exception to that, really the only exception, is the mitigating measures of ordinary eyeglasses. That can be considered for the purposes of determining whether a person's impairment and eyesight substantially limits the ability to see. All right, and then we talked about the condition, manner, and duration. This is, again, still on substantial limitation. It may be useful to consider, as compared to most people in the population, the condition under which an individual performs a major life activity, the manner in which he performs it, or the duration. But you just recognize that the connection between the physical and mental impairment and the major life activity through the substantial limitation piece is not designed to be difficult to satisfy. And I've given you some numerous examples of what impairments substantially limit major life activities. Obviously, deafness, blindness, intellectual disabilities. This, again, this may be a little bit more difficult to define and observe, but that substantially limits brain function. Missing limbs, autism, cancer, any of those on the left-hand side, those are automatically disabilities. That is the way the EEOC is looking at them, and the courts are going to defer to that. So cerebral palsy, diabetes, epilepsy, HIV infection, multiple sclerosis, and then I've given you a number at the bottom there, the major depressive disorders, bipolar disorder, post-traumatic stress disorder, obsessive-compulsive, and schizophrenia. All of those substantially limit brain function. So we've got disability. And then the record of having such a disability, I've talked about this briefly. An individual has a record if he or she has a history of, even if they've been misclassified as having a physical or mental impairment, that substantially limits one or more major activities. And that individual may be entitled to reasonable accommodation if needed and related to the past disability. And what we're talking about there, and you'll see that at the end, where the individual may be in need of follow-up or monitoring appointments with a healthcare provider. All of that could be provided by the agency as a reasonable accommodation for the record of a disability, cancer, bipolar disorder, depression, epilepsy, that previously limited but no longer substantially limited. Then the regarded as. This is that last piece and this is what I was talking about earlier, an individual meets the requirement of being regarded as if the individual establishes that he or she has been subjected to an action prohibited under the Act because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. That's not necessary for this piece. But you will see down there at the bottom that no reasonable accommodation is required for an individual who meets the definition of individual with a disability solely by establishing that he or she is regarded as having a physical or mental impairment. And just recognize, too, in the middle there, transitory or minor impairments, such as an employee breaks his or her legs, no other complications associated with it. That would be a transitory and minor impairment that would not lend itself towards the regarded as prong. So if the agency had to take some action based upon the person's absence, that would not be in violation of the ADA. And then finally here, where an individual is not challenging a covered entity's action to failure to reasonably accommodate and does not require a reasonable accommodation, they don't need to go through the actual or the record of prongs. All they need to do is just simply go through the regarded as prong. And that, as I said, is typically going to be found in your retaliation cases, your hostile work environment cases, your disparate treatment cases. A person gets punished because of a perception that the person has a disability. You know, let's say a person comes into an employment interview, and a person has a scar, a visible scar on the face, and the individual who's conducting the interview says, "I don't want somebody working for me who's got that kind of a disgusting scar on the face." That would be construed as a regarded as problem. If the individual is screened out because of that, that would be impermissible under the ADA and thus the Rehabilitation. Okay, pre-employment inquiries. This may be something that interests you if you are conducting interviews. It is acceptable to make pre-employment inquiry into the ability of an applicant to perform the job-related functions. However, it is generally unacceptable to make inquiry of a job applicant as to whether he or she is an individual with a disability or as to the nature or severity of such a disability. There's an exception to that, though, however. If you know that the applicant has a disability, it's obvious. Person comes in a wheelchair, right? Or the applicant self-discloses, which does happen. The employer reasonably believes that the applicant might need accommodation to perform the duties, then you may ask two questions. This is from the EEOC. First question, do you need reasonable accommodation to perform the duties? And if so, what accommodations do you believe that you need? I wouldn't suggest you go any further than that. You know, if the person says, yes, I can perform the essential functions with some reasonable accommodation, then you just have to evaluate that as you would anyone else. But those are the two questions you can ask. Okay, so we've gone through the disability piece of the policy. Remember, the policy requires us to provide reasonable accommodation to those individuals, the known physical or mental or intellectual limitations of a qualified individual who is either an employee or an applicant, unless providing that reasonable accommodation would present an undue hardship. So now we have to define what it means to be a qualified individual with a disability. So an individual has a disability, he or she becomes qualified for a reasonable accommodation if two things. Number one, the individual satisfies the requisite skill, experience, and education and other job-related requirements, standards of the employment position, that individual holds or desires. And two, this is the big one, the individual can, with or without reasonable accommodation, perform the essential functions of the position that the person, that individual holds or desires. Okay, so you've got those two. And that first piece is really, for example, for attorneys in the solicitor's office, we've got an obligation to maintain membership in a bar. We've got to pass we got to go through law school, get our bar membership. That would be a job-related requirement. If an individual tried to apply for a position as an attorney with the solicitor's office and said, yes, I have a master's degree in political science, but I don't have my law degree and I haven't passed the bar, you could exclude that person. And you certainly wouldn't have to help that individual go through law school, even if he or she said, well, the reason I can't get through law school is I have an intellectual disability that prevents me from being able to study at the times that I need to be able to study for law school. So you have to excuse that problem. The agency would say absolutely not. You know, that's that first piece. The second piece is the essential functions. And that is all tied to the job that the individual holds or desires. Okay, so the first piece, the requisite skill, experience, and education, and other job-related requirements. An individual is not qualified if he or she doesn't have the background required for the job. And you're not required to provide that reasonable accommodation so that an individual can satisfy that. And I've given you a case there from 2011. And there are numerous cases standing for that proposition, but this one, the individual wanted help in obtaining a provisional teaching certificate. That was a job-related requirement. Couldn't get a job with the Board of Trustees of Boundary School District number 101 unless the individual had that provisional teaching certificate. The plaintiff said, yeah, I've got a disability that prevents me from doing that, so could you assist me? And the court says, no need to do that. But beware, if there are job-related requirements, you must, the DOI must, defend the requirement and justify the need for the requirement. If the individual is saying, well, I can't meet that requirement because of my disability. Now licenses and certifications are fairly easily defended, right? So if we've got doctors, lawyers, or let's say pilots, all of whom would have necessary licenses and certifications, those would be defended, right? You as a legitimate requirement. But what about requirements associated with the level of danger in a job? We're talking about. What about and you have to have standards that are related, job-related, and consistent with business necessity. You could have a qualification standard that requires an individual not to provide a direct threat. And I dealt with this personally in a matter where an individual was an electrician for one of the DOI clients, and he had attention deficit disorder that caused him to kind of lose focus on activity. But for an electrician, that could be deadly. And in fact, he did lose some attentiveness at one point and almost electrocuted himself. He put his hand through an arc. The agency wanted to discipline the individual for his inattentiveness. And I suggested, I said, well, the problem is that his inattentiveness is based upon his disability, because there was no question he was disabled. Right? It was better in that circumstance to say, but you've got a qualification standard that really he can't meet because he poses a direct threat to himself or potentially to others because of his disability. And so I call your attention to that qualification standard. Now, that's not going to be an essential function, but it is something to consider in the process of reasonable accommodation. And I've fleshed out a little bit more in that last bullet. If an employee fails to meet a qualification standard because he or she poses a direct threat because of a disability, then DOI must determine whether the reasonable accommodation could eliminate that risk or reduce it to an acceptable level. Okay, so here's another illustration. And I'm going to turn this over to others in our group because I know they had a much heavier hand than I in this matter. You see that this is a DOI case. In this illustration, we had the employer reassigned a park ranger with law enforcement authority to a non-law enforcement position, a staff ranger. And others on the panel here can flesh this out a little bit more. But generally what happened was the employer took the personnel action based upon the uncontrolled diabetes, not just the existence of diabetes, but the uncontrolled diabetes and the employment-related adverse consequences of a hypoglycemic reaction, the inability to complete a dangerous arrest or the inability to respond to a medical emergency. And the standard that was imposed was you have to have an employee under these circumstances who can complete a dangerous arrest or who can respond to a medical emergency. And this particular employee was unable to do that. So anybody else on that panel want to jump in on that?
Yeah, this is Horace. There was a couple of things I wanted to mention, and thanks, Gavin. One of the things that was at issue in this case, and it sort of got to the point where it appeared as if this employee was arguing both sides, but we were dealing with the medical standard, as it were. And one of the things, during the administrative phase of the hearing, was a very straightforward case, and that's the way the EEOC took it. We prevailed on that, and then he appealed. He goes to the district court, and then from there on, as you can see, he went to the Court of Appeals. But what we had, in addition to the medical standard, his argument was that, look, the agency is regarding me as a person with a disability. His claim initially was that I'm not disabled, that I can nonetheless perform the critical elements of my job, the critical functions, because number one, and what he relied more than anything on was that he had been doing it for 19 years, and even though he had this uncontrolled diabetes, it had never prevented him from doing anything that was required of his job. He's never had any problems with that. And so to say that he was regarded as being disabled, and he broadened that essentially to say that people with disabilities, with diabetes, the Park Service treats them adversely. Well, the Park Service came back, and one of the points I wanted to make was when you're dealing with regarded as, to deal with that, because this one was not so much an accommodation case, was that it required us to get data. And what we had to do, and it worked in our favor, and it was evidence of not regarding an individual with as a disability or with a disability, was that we found that within the Park Service, I believe there was 69, this is nationwide, individuals who had the same type of diabetes as this person, and while he may not have been the only one who was decommissioned, as it were in this case, his law enforcement commission was revoked, the Park Service did not treat these individually any different. In other words, yes, you can perform the duties of your job, and thus we are not treating you any differently, merely because you have a disability. So of course they recognize the disability. And I'm sure maybe Mr. Garvey would like to talk about what we had in this case is that his was uncontrolled. And the medical standard didn't change. But it was the gathering in part of all of the information that we got, the data, to show that the Park Service did not regard this individual or any individual. Yes, you do have a disability, but it was not disqualifying. And that was the point that I want to make on that.
Excellent. Thank you, Horace. And Bob, do you want anything on that? You go right ahead. I'll just move on to the illustration if not. The next
I'll chime in for a second here. The broad area that we're talking about here falls under what we call the direct threat analysis, which permits and in some sense requires an agency when they have a situation where an individual either is covered by medical standards under 5 CFR 339 that permits an agency to set standards for individuals that are in arduous or hazardous occupations, or individuals that have physical requirements in their job wherein an individual's medical condition is necessarily an important component of their capabilities to do the job, to go through a direct threat analysis and process when they're looking at medical conditions to, in a individualized case-by-case determination, look at the individual's ability to do that job safely and efficiently. So in addition to the undue hardship sort of inquiry, we also have an undue risk of harm inquiry limited to those positions, again, that either have medical standards or have physical requirements which obviously need to be well articulated in the PDs and so on. It's a separate area. I would just alert you that when you have a park ranger or an inspector covered under standards, a wildland firefighter, a number of different occupations within the department, that this is an additional area that you need to consider. Those areas need to be considered on a case-by-case basis based on their own merits, the specifics of the medical condition, the specifics of the safety risk that they are under, and so on. When Horace talked about the uncontrolled diabetes piece of it, it was the uncontrolled piece, which was well documented, and I might also add that this particular individual was given actually 3 bites at the apple, that the initial disqualification was waived with reasonable accommodation conditions that included verification of their ability to control their diabetes and reduce the risk of an untoward event like a hypoglycemic reaction to an acceptable level, and that they, over a period of time, failed to meet those conditions. And so the agency did a very, very detailed case-by-case assessment, was extraordinarily forbearing in trying to keep this individual on the job, and it was only after repeated evidence coming to light of their inability to control their diabetes were they actually disqualified and supplicantly appealed it. And that's it.
Thanks, Bob, and thank you to Horace. Both of you have articulately addressed all those concerns in there, and I think this evidence is, as both Bob and Horace have mentioned, that the individual has to be able to satisfy those qualification standards, and in this case, they would be medically related. And if an individual can't, even without regard to the essential functions, that individual is not qualified, and therefore certainly couldn't be provided with reasonable accommodation under any circumstance. So now let's look at illustration 4. I think it'll take it even further on this. If an employer, and this is outside of DOI, but I thought it was useful as a very recent case, if an employer advertises for a position and they describe that as a vehicle technician, the duties of which infrequently require the operation of work, and an individual then applies but is screened out because that person can't obtain a commercial driver's license, what happens? The commercial driver's license there is the qualification standard. That is the requirement associated with the job. It's not an essential function. But remember, it's twofold. They have to, in order to be qualified, they have to meet the skills, the expertise. They have to satisfy all the qualification standards, and they also have to be able to, with or without reasonable accommodation, perform the essential function. But that first piece, the individual couldn't get the driver's license. But in this case, the court said, well, why does a vehicle technician need a commercial driver's license? And they turned back to Federal Express, and Federal Express said, well, because there are instances when, after the technician has done his job, he has to drive the truck, so therefore needs a commercial driver's license. And the court said, great, we understand what you're saying. How often does that happen? And Federal Express scratched its head and said, well, the documentation we have is that it's about 4 hours per year. The court said, well, that can't possibly be a standard that you're going to, the basis on which you're going to screen people out. So the court in that case said, sorry, that's not a standard that we will support for the purposes of saying that an individual is out. And by the way, you can imagine that the individual couldn't get the driver's license because of that disability. That was the problem. So be careful. If you've got a standard, it must be more akin to what we were talking about in that Atkins case, where it does have a job relation and it has a consistency with business consent. Okay. So also make sure that when we have job-related requirements, that the requirements or the standards are consistently applied. The court in Taylor v. Rice addressed a situation in which the Department of State had a qualification standard that required foreign service officers to serve worldwide. But they did give exceptions. They gave exceptions to people with asthma. They gave some other exceptions. And in this case, the individual had HIV, Taylor did, and was unable to serve worldwide, could only serve in about 70% of the locations. But the court said because that job-related requirement has not been consistently applied, it's rejected. And therefore, you cannot exclude Taylor on the basis of the inability to satisfy that job-related requirement. It's got to be consistently applied or not applied. Okay, now we've got that first piece on qualified individuals. Remember now, so you can track with us. We've talked about disability. We're into that qualified individual with the disability piece. We've talked about the first part of being a qualified individual. That is satisfaction of the skills, the requirements, the standards associated with the job. The second piece is the individual has to, with or without reasonable accommodation, perform the essential functions of the job. Those essential functions are job duties that are so fundamental to the position that the individual cannot do the job without being able to perform them. And you'll see this again in the Civil Rights Directive. You have to distinguish between and among essential and marginal functions. Does the position exist to perform the duties? How many employees are available to perform the duties? And is the function highly specified? I'm just getting word that apparently the main interior building is going to have a shelter-in-place drill at 3 o'clock. Do we have to? Okay, I guess we're going to have a 15-minute intermission here in 5 minutes. I apologize for that. I had no knowledge until just moments ago, but we'll take a short break. You can do whatever else you do. But before we get to that, are they going to give us some type of It will come out. Okay. All right. For those of you in main interior, apparently we're going to get that blaring sound, and then we will ring off. Everybody, we can just keep the connection up. Yeah, we'll keep the connection up, and then we'll come back. Okay. But before we get to that, let me run through some of the evidence that's relevant to essential functions. First of all, agency judgment. That is relevant to whether a job duty is an essential function. The written job description, time spent performing those functions, the consequences of not requiring the company to perform those functions, the terms of the collective bargaining agreement, work experience, etc. Now, if we get to this point, the agency department has to prove which functions are essential. On the other side, if you're a disabled individual, you have to prove that you can meet those essential functions, perform them in order to satisfy the requirements under REACT. So let's look at agency judgment. The courts are going to give a significant degree of deference to the employer's business judgment. Not entirely, but you see the case there, the 2012 case in which the First Circuit recognized that because the employer had indisputably characterized passing that series exam as an essential function, they held all the employees to that. It's highly probative, but not conclusive, and the courts are never going to advocate their independent review to determine what is or is not an essential function. Next, at the summary judgment stage, the employer's judgment is not likely to be dispositive as to whether something is or is not essential. When the evidence is, otherwise the employer would be able to assert that any particular function is essential. With regard further to essential or the agency judgment, despite giving that considerable deference, the court has rejected assertions that punctuality was an essential function of a particular job. This may be important to some, or even attendance as to whether that is an essential function. And we do have discussion about that, because in this case, the employee whose duties required conducting home visits, processing social assessment, had schizophrenia. The treatment which prevented him from arriving at work at a specific time each day, the court said that punctuality is not essential. So when that individual with schizophrenia said, look, what I want for reasonable accommodation is the ability to arrive a little late, the employer says, no, sorry, we can't, because your punctuality is an essential function. So if you can't perform that with or without reasonable accommodation, then you can't do this job. You're not qualified for the job and therefore not qualified for reasonable accommodation. And the court said, sorry, that's not an essential function. So you have to look at it outside the context of the punctuality. And in that case, other than punctuality, the employee was able to meet the essential functions, and so the request for reasonable accommodation in the form of arrival at late work was considered a reasonable accommodation. Job description. This is not going to be the be and end all, but you should look at job descriptions, position descriptions, to ensure that they accurately and completely reflect fundamental job duties. Many that I've seen, not in the solicitor's office, but our clients, they will include marginal functions. Those should be eliminated, eliminated from the essential functions and distinguished. They can still be in the PD, but they have to be identified as marginal functions. And I've given you a couple cases, some very recent, where traveling was required, especially for an airplane mechanic who had to be able to deploy. And here might be something that you would find interesting. The essential functions of a family social or services worker, because of the way in which the PD was written, it required the individual to deal with stressful cases of clients because the job description itself required frequent exposure to physical and verbal abuse, one of a stressful environment, and involved regular contact with clients. That might be something that finds its way into PDs that that you impose upon your subordinate, because that might be relevant, and therefore it could be an essential function. If the individual could not satisfy that with or without reasonable accommodation, then maybe not qualified individual, and therefore not entitled to reasonable accommodation. The amount of time spent performing that, this is not precisely measured. There are cases, this one in 2006, where it said, look, even 10% could be an essential function, especially when other functions only demand about the same time, 10 to 25%. On the other hand, and this is that Federal Express case, the individual only spends a minuscule amount of time performing that function, that duty, it's not an essential. How about the ability to shoot a firearm accurately? Would that represent an essential function for a law enforcement officer, or would it be more likely to be established as a qualification requirement? That's at the end there of that last slide. How about the consequences of not requiring the individual to perform that duty as a part of the essential function analysis? For example, in the Wardia case, the ability to screen inmates, although rarely done, wasn't done frequently, but it was essential because if that couldn't be done, there were going to be serious consequences if that was not performed by someone in the position. The adverse consequences would be obvious. In terms of the collective bargaining agreement, would be evidence or relevant to the essential function analysis, and the actual experience of incumbents and prior employees as evidence of an essential function. There are, I've just given you a list. What about these various duties or abilities? Would they fall into or not fall into the category of essential function? How about the ability to handle stress as an essential function? Is that job duty so fundamental to the position that the employee cannot succeed if unable to perform that task? If the answer is yes, that should find its way into a position description. How about the regular, predictable attendance at work? Is that an essential function? I know that many of you would probably shake your head yes or answer verbally yes. It is an essential function. The EEOC would disagree with you 100%. The EEOC's policy says attendance at work is not, I repeat, not an essential function. Now, it may be a standard imposed on all the employees. So rather than looking at it as an essential function, maybe we look at it as a standard that is imposed uniformly on everyone. And then if the individual can't satisfy that standard, then they're not qualified. Because what the individual may be looking for is the ability not to attend work. If they don't want to come at all, you've got to look at leave as a potential reasonable accommodation. What about the ability of an individual to get along with coworkers? That an essential function. How about good judgment? Is that an essential function? And it may be for some. You know, I know that you will find cases, I didn't have time to identify them all, but there are cases that stand for the proposition that all of those are essential functions, and there are also cases that equally stand for the opposing proposition. Is the ability to work independently an essential function? Likely for an attorney. How about the ability to stay awake? The EEOC has taken the rather unusual position that consciousness on the job is not an essential function. Now, maybe it's required to perform the essential functions, so says the EEOC, but consciousness itself is not an essential function. The court rejected that, by the way. Said no, in that particular case it was a railroad operator. And that is the getting the announcement. Okay. I have to shelter in place. I'll talk to you all in 15 minutes.
Okay, keep the lines open and we'll be back.
One moment, please.
The website or the database, or just in Lexis or Westlaw. So there are plenty of cases on that. Plus the ability to write, speak, stand, sit, lift, are those essential functions. You know, I would submit to you that if our position descriptions, like for attorneys, include the verb write, that may need to be changed. I mean, it may not necessarily be the physical ability to write. Perhaps the verb to generate or the infinitive to generate might be a better way to describe that. Because an individual could get, for example, with the inability to write, voice recognition software and could still generate product that way. What we would need is the ability to analyze, those types of things. How about the ability to travel? Is that an essential function? And again, for some positions, likely yes. For all positions, no. I'm just giving you in the last page there, those two, a number of different problems that could be construed as essential functions that may come up in the context of a reasonable accommodation analysis. Well, let me give you an illustration. This one comes from a recent case in the federal sector. A supervisor produces a note from healthcare providers, and to be specific, there were 3 healthcare providers in this case, 2 of whom opine that the supervisor should not have any workplace conduct or contact with former subordinates and should have very limited workplace contact with supervisors, colleagues, and the public. So essentially what the docs were saying is that this supervisor shouldn't have contact up, down, or with the public, or sideways with colleagues. And the supervisor then sought reasonable accommodation consistent with those medical opinions, and more or less wanted to be by themselves. And that was it. Is that supervisor a qualified individual? Well, your question should be, under this illustration, because I have, again, by design activity, well, what are the essential functions of that job? Does that job require interaction with the public? Does it require interaction with the supervisor? And most likely, like any job, it would require some workplace contact, or with colleagues. And the court in that case found, the Fifth Circuit said, yeah, of course, in that particular matter, even the job description and the judgment of the agency, both of which are relevant to essential functions, were consistent in saying that supervisory job requires, as an essential function, regular workplace conduct with former subordinates, with supervisors, with colleagues, and with the public. And so if that supervisor is saying, even though it's got, medical documentation, is saying that that can't be performed, that essential function, then the individual is not qualified for reasonable accommodation. So remember, maybe you're disabled and interacting with individuals, if whatever the impairment was caused that inability to interact, that's a disability. But it doesn't necessarily mean, and in this case it did not mean, that that person, although disabled, was entitled to a reasonable accommodation. Why? Because the individual was not qualified. And then the question is, why were they not qualified? They weren't qualified because they could not perform the essential functions, interaction, with or without reasonable accommodation. The reasonable accommodation that they wanted was no interaction. And because it's an essential function, that's not reasonable. That would be an undue hardship. So the court rejected that proposition by the supervisor and said, sorry, you're not qualified and therefore not entitled to a reasonable accommodation. How about attendance as an essential function? Many disability rights advocates insist that attendance is not an essential function, and the EEOC agrees with that. Attendance is not an essential function. You'll find that in their enforcement guidance on reasonable accommodation and undue hardship. I'm giving you the date and the footnote. But I want to talk about this a little bit more because I know this is an issue with a number of my clients. Many courts disagreeing with the EEOC and disability rights advocates have determined that attendance is an essential function for various jobs. In a recent case, the Eighth Circuit said regular and dependable attendance is a requirement of the position, and the employer was not qualified due to being excessively absent from work. Employers generally need not accommodate erratic or unreliable attendance. How about an individual, even working for the solicitor's office, who might, maybe not an attorney, but needs to support an attorney by getting documents out, by editing documents. If he or she is not available for work, it may be that that unavailability as a result of poor attendance is a violation of that essential function, and therefore the individual cannot perform the essential functions and is not qualified. So the agency could take action on that basis and would not need to reasonably accommodate by allowing the poor attendance. Attendance as a job-related requirement. Here's a different form of the analysis. Let's look at this less about whether it's an essential function, right? Remember, qualified as an individual with a disability requires two things. You got to be able to meet the job requirements, those standards, whether they're medical or otherwise, and you have to be able to perform the essential function with or without reasonable accommodation. But if we look at attendance as a job-related requirement that we impose on all maybe we get there. And the EEOC in 2004 agreed. Regular attendance is a uniformly applied conduct rule that is job-related and consistent with business necessity. An employer may discipline an employee with a disability for engaging in such misconduct if it would impose the same discipline on another employee without that. So there is a fix. If you are confronted with an employee whose attendance is poor, you may be able to solve it this way. And if you have the disability that prevents the attendance, then what you're trying to do is to find a way in which to establish an ability to meet the job-related requirements or the essential functions, although unable to attend on a regular basis. That's a hard nut to crack. And a final comment on attendance. You have to analyze the need for the physical presence at the workplace. Because what we're really talking about here is what? If the individual can't attend the official location, they're looking for telework or leave. And telecommuting is a huge issue right now. EEOC versus Ford out of the Sixth Circuit, established that for many positions, regular attendance at the workplace is undoubtedly essential. But, and here's the kicker, as technology has advanced, attendance at the workplace can no longer be assumed to mean attendance at the employer's physical location. So if an individual could still get the job done, although not at the physical location, then there might be a to reasonably accommodate through telework. That might be a solution to the problem. Then the question would be, well, how much telework would be necessary? All right, but before we go on to the forms of reasonable accommodation, because at this point we've gone through disability, we're getting to the end of what it means to be a qualified individual with disability. And here are some other factors, other evidence that may be relevant to that analysis as to whether an individual is qualified. For example, satisfactory performance evaluation. If an individual is satisfactorily performing his or her job, that's relevant to whether the individual is qualified. A statement from healthcare providers. If the healthcare provider...
There's some crosstalk going on. I need more muted phones.
That's not what we're using.
I agree with you on that. If you could mute your phone if you're... Yep, thanks.
That's what Dan sent?
Okay, well, I'll just continue. Statements from healthcare providers. That might be relevant as to whether an individual is qualified. Now, that cuts both ways, remember. If the healthcare provider says, my patient cannot perform the duties of that job, then the employee can't distance himself or herself from that healthcare provider statement.
It looks different than
alternatively, if the healthcare provider says, yes, my patient can perform those essential functions, and the healthcare provider has gone through the analysis, that's relevant. What about statements in other forums? And inconsistent statements. For example, the EEOC in their enforcement guidance on the effective representations made in applications for benefits on the determination of whether a person is qualified, back in '97, has said that the inconsistent statement in, let's say, application for disability benefits may be relevant, but never an absolute bar to finding that the individual is qualified. All of that is just designed to show that there are other ways in which an employee or the employer could assess the qualification of the individual. So be aware of that. And let me also say that with regard to the healthcare providers, I recently had a case within the last 2 weeks in which the employee's healthcare provider said, hello, hello.
This was yours.
Hey, there's a female voice that is having a conversation while Gavin is trying to talk. Could that person please put their mute button on?
Thank you. Perfect. I just had a case in which the healthcare provider said that the patient could not use, and it was a very blue-collar work. It was kind of a hydro repair person in a power plant. Could not use any equipment that caused a vibration. And that was the essential function. That was what the job description required. That is what the agency's judgment required. And so the healthcare provider saying, my patient can't do that, made clear that his patient could not perform the essential functions of that job. And really the remedy there was could not possibly accommodate with any reasonable accommodation, so the employee left the employer the DOI. That was the only alternative. And there was no reassignment of it. Okay, so we're now at that point where we talk specifically about reasonable accommodation, We've talked about disability. We've talked about a qualified individual with a disability. Those individuals are entitled to reasonable accommodations unless there's a undue hardship. What do we mean by that reasonable accommodation? So here's the process that you employ. First of all, you establish that you've got a qualified individual with a disability. We've talked about that. You have to have knowledge of the disability and the need for reasonable accommodation. Normally that's going to come from the employee. It's going to come specifically from the employee. Then after you have that knowledge and the need, there's an individualized inquiry into that disability and the need for accommodation, unless it's obvious. And then you grant or deny the reasonable accommodation based upon that individualized inquiry. This should be an interactive process. It's a give and take. If you have enough, don't ask for more. If you need more, document, document, document. So all of this is that, working closely with the employee to figure out what limitations exist and how the agency can help. It may not be possible to help, but your question is, how can I help? Okay, so our guidance on reasonable. What do we mean by that? Well, it's reasonable on its face. It's got to be effective, so says the EEOC. And some courts, you'll find this in a lot of court documents. Talk about reasonableness in the sense of both efficacious and proportional to cost. I caution you, however, watch the cost issue, because that is an agency cost issue, likely not a facility cost issue. We'll talk about that on undue hardship. What do we mean by reasonable accommodation? Well, there are three ways to reasonably accommodate. You can modify or adjust the job application process to enable a qualified applicant with a disability to be considered for the position. You can modify or adjust the work environment or the manner or circumstance under which the position held or desired is customarily performed. And let me stop right there on number two. I see sometimes in clients that they get stuck in believing that the way in which the job is performed has to be done the way it was previously. And things have changed, as the courts have recognized. We've got advances. So there may need to be, kind of a flexibility on the part of managers, on supervisors, to recognize we can change the way in which the manner or the circumstances of the position are performed and still get the job done. Because that's the last piece of it. That enables a qualified individual with a disability, to perform the essential functions of that job. And lastly, a reasonable accommodation means modifying or adjusting certain things that enable an employee with a disability to enjoy the benefits and privileges of employment as are enjoyed by others similarly situated. You may ask the question, what do you mean by that? Well, let's say an employer has allocated parking for all employees, and one individual who has a walking-related disability needs closer access. That might be something that is possible to give to a disabled employee. Because you're trying to make it an even playing field, that may be possible. It would not mean, let's say, that if an employee for problems associated with commuting couldn't take the metro, that he or she then would be entitled to a monetary subsidy. That would not be an equal benefit or privilege of employment. Or, for example, let's say that on a monthly basis or a weekly basis, the entire office goes out for lunch. And it's a very valuable opportunity for the employees because they have direct access with the supervisor. They can chat with him or her while in a fairly relaxed environment. But if an employee is confined to a wheelchair or is on crutches and can't get into the location where the agency normally conducts these meetings, that would have to change, because otherwise you're excluding the person who can't access that facility from the same equal benefits and privileges of employment. Okay, RA examples. What do we mean? Well, you can always modify job application procedures to give those individuals with a disability, qualified individuals with a disability, a fair opportunity to compete. That's what we're talking about there. The job application process, got to have a fair competition. Or we can modify facilities to make them readily accessible. We can restructure the job. Again, remember, eliminating marginal job functions is always available. You never have to keep marginal job functions. Part-time work, modify work schedule, paid or unpaid leave, all of those can be provided as reasonable accommodation. We can acquire or modify equipment or devices, provide qualified readers, interpreters, or adjust and modify exams, training materials, and policies. And you see at the bottom, the employee, that's the employer. may need to provide more than one. Oh, so I said the employee may need more than one, and the employer may need to provide that more than one form. For example, on your when I've listed acquisition or modification of equipment or devices, I know there's a big movement afoot with standing at workstations. If an individual is disabled and needs that form of a work desk that can move, that may be a reasonable accommodation. That may be. But if an individual is not disabled, then you're not talking about a reasonable accommodation. You may provide that as an assistance. It may be something that the agency wants to provide, but it would not be required to under the Rehabilitation Act. Other related issues. Because an employer has no obligation to alter barriers outside the workplace, an employer need not provide any personal use items. No wheelchairs, no eyeglasses, no prosthetic limbs, no hot pots, no refrigerators, all that, and you'll see the site there. An employer also need not monitor any employee's medication. An employer need not, but may, assign a new supervisor. You're never obligated to assign a new supervisor. It may be that the supervisor is causing some problems or exacerbating the employee's disabilities, and you may find, well, might be in our best interest to do that, but it's not a requirement. It would not be a requirement to do that. Now, I also caution you, if the supervisor is creating problems, that may become a retaliatory environment, maybe a hostile work environment, that would be outside the scope of our discussion here, but still relevant to discrimination in the workplace. Finally, the employer need not, but may, eliminate any essential functions. Never obligated to take away essential functions, but you can always do that. It's always permissible to do that. So how do we get there? We've now talked about a number of reasonable accommodations and issues associated with it. What has to happen? The individual has a disability. The individual characterizes himself or herself as qualified. What occurs? Well, the agency does not have to be psychic or clairvoyant. There's no requirement, however, that the agency gain knowledge of the employee's need from any formal notice. I will, however, refer you to the bulletin, I'm looking for the number, 2014-02, the Civil Rights Bulletin. In that document, and I know I have a slide here later on, I think it's at attachment 9. It may give you information about how to go about the gathering of information so that you get the notice from the employee. There's no requirement that the agency gain knowledge directly from an individual. It can come from a family member, a friend, a healthcare professional, some other person, but you got to consider the relationship along with the seriousness of the condition and possible motive. What you don't want is individuals asserting that a colleague has or another person has a disability when in fact that's false. So you do have to assess the reliability of the source, but you can't ignore it just because it comes from a third party. So illustration 6. A healthcare provider prescribes medication for...
Gavin, let me jump in here real quick.
Go right ahead. I'll leave it on that last one there, and you go right ahead.
In the consideration of reasonable accommodation, sometimes agencies appear to be reluctant because they don't know if it's going to work. Reasonable accommodation, as Gavin has pointed out, is an interactive process. You can test reasonable accommodations. There's no reason not to try something simply because you don't think it's going to work, and that's on both the side of the agency and the individuals. So sometimes you're going to need to put a reasonable accommodation to the test and see whether performance can be maintained or conduct can be maintained or whatever it is, whatever measure that the agency is using to determine the success of something. And similarly, an individual may need to try something out to see if 2 or 3 days or 4 days of telework is going to work, so that we need to sensitize, if you will, clients that it's okay to test something, and if it doesn't work, to go back to the interactive process to try to determine what does work, and also that the agency can propose alternate reasonable accommodation that meet the requirements. They don't always have to take what the individual prefers as gospel. So it really is an interactive process, and the better job the agency does at showing that they're leaving no stone unturned in a effort to reasonably accommodate an individual, the better off that they are down the road if something doesn't work.
Absolutely. And I had a case, I don't think I cited it here, but the First Circuit just recently decided that an employee's refusal to try the reasonable accommodation identified by the agency made that individual unqualified and then did not entitle the individual to reasonable accommodation because the person asserted that the agency failed to reasonably accommodate. The court said, but they offered you this reasonable accommodation and you refused. It was in the form of a workplace that was much more quiet. Yeah, so I mean, Bob's absolutely right. And make sure you are documenting throughout the process to protect you and to protect the individual who has asserted a need for a reasonable accommodation. So if an individual, however, doesn't identify, and this is illustration 6.
Gavin, this is Nolan Chishido. I had a question on that in terms of, you know, your example 2 as well. So if you go down the road of testing a reasonable accommodation, let's say, and the employee says, yeah, it works well for me, and the employer says, well, it doesn't work so well for us, are we down the road to showing that it's an undue hardship for us to accommodate that particular measure?
No, and let me show you an example. I just rolled through to 12. So I've just scrolled down to illustration 12 because I think it answers your question. Let's assume that an employer grants an attorney a modified work schedule to accommodate her sleep-related disability. All right? The new schedule, which prevents the attorney from interacting regularly with other attorneys and paralegals, results in missed deadlines and incomplete work. Right? So we've given the accommodation, but it's not working for a number of reasons. Missed deadlines, incomplete work. In addition, other attorneys now have to handle more work because of the attorney's absence as a result of the modified schedule. Okay, as Bob said, we can try that. But let's assume we try it and it does not work. Now, the agency is still going to have to show that that's an undue hardship. Can't just say, sorry, we've tried it, it's not going to work. But if the agency, and in this case, this is actually from the EEOC, this illustration 12, they would support your position as an employer to say, we've tried it, we thought it would work, it's not working, it's an undue hardship. Now, that doesn't end the process. What you would have to do is try, again, to say, how can we help it? This isn't going to do it. If that's all you're asking for is a modified schedule, we have to reject that as an undue hardship. You would not be compelled to do that, kind of as you described, because, you know, the water's over the dam or the toothpaste out of the tube. You're not forced to do that forever. You can revisit it, and that's why it is beneficial, even as you're going through and working in an interactive process, to say, look, let's try this for a couple of months. Let's give you the reasonable accommodation, but we're not pinned in forever because we need to see if it works. So, yeah, you're not stuck on it, but as Bob mentioned, and as Horst mentioned previously, the effort is going to go a long way, too, also to establish that the agency made a good faith gesture in trying to reasonably accommodate. But you're not stuck forever, no. And that goes back to what we had talked about even on 2. So in this case, what I've talked about in the illustration, if the attorney doesn't come forward, right, because we got bipolar disorder, and even though the concentration at work has deteriorated and the performance deteriorates as a result, if the attorney says, well, I didn't come forward because I was embarrassed, the EEOC, and this comes for some of their fact sheets, would say, sorry, attorney, you're out on that. You cannot expect the agency to understand. Now, I am distinguishing this from certain circumstances where the employer knows that the employee can't, for disability-related reasons, communicate that need. But this isn't one of those. I mean, I'm talking about people with autism, individuals who might not be able to put their thoughts together. The attorney here, based on the illustration, is just reluctant to disclose that. If, for example, and I've changed it, what if the agency knew? What if the employer knew about the bipolar disorder as identified by the attorney? Or, to change the illustration a little bit more, what if after the performance deteriorates, the supervisor comes forward and says, you know what, attorney, I'm going to have to do something about this. Perhaps I'm going to have to reduce or put you on reduce your employment, your EPAP, or I'll have to put you on a performance improvement plan because your performance is now unacceptable. And at that point, the attorney says, oh my gosh, let me tell you what's going on. I have bipolar disorder. I've got medication that's interfering with my ability to concentrate. That's the reason for my performance problem. Can you help me work this issue out? At that point, now you're on notice, and the employer has an obligation to at least interact, because under these circumstances, accept the fact that the employee, the attorney, could perform the essential functions. So now you have an obligation under the DOI policy to provide the reasonable accommodation because the individual is qualified, unless it poses an undue hardship. So that's when you get into the interactive process to try to determine. It would make no sense, though, and that's why I have a question there, to start disciplining if you know of the employee's problems. But if the employee doesn't disclose, you do not have an obligation to be cited or clairvoyant. Okay, and here's another illustration. If the employee, let's say it's a supervisory attorney, requests 6 weeks off to get treatment for a back problem, would that trigger the obligation on the part of the agency to interact? EEOC says absolutely. It might be construed as an FMLA issue, but in their fact sheet that deals with the FMLA, the ADA, and Title VII, they've got an example very much like this. They would say that, quote, 6 weeks off to get treatment for a back problem, end quote, gives the agency enough information to move forward. It alerts them to what they would construe to be sufficient information to interact. It's pretty basic. It's not clear. It's a little vague, but so says the EEOC. That triggers it. And I've given you 2 other cases there. In Johnson Morgan Department of Labor, that was in 2013. There was a request for a different computer monitor because the existing monitor hurt the person's eyes and causes headaches. That was enough to trigger the employer's responsibility. It satisfied the employee's duty to request. Another example, the request for relocation to another office in the same building because of noise sensitivity resulting from experience as a Holocaust survivor in the Department of Justice versus, or the Federal versus Department of Justice. EEOC again said that was sufficient to trigger the agency's responsibility to interact. So you can't play ostrich if you get what you consider to be a vague request. You may have to explore that a little bit more fully. Another example, employee and IT specialist. We have those as well in the solicitor's office. Suffers from chronic fatigue and informs the supervisor that problems are coming back again and he or she is having difficulty getting insurance to pay for a medical device. Is that sufficient? No. Says, well, at least the Sixth Circuit in this year said it's got to be something more than that. Simply informing the supervisor that the problems are coming back, having difficulty getting the insurance company to pay for the advice. You should still say, what? Under these circumstances, how can I help you? I can't help you with the insurance company. Is there anything I can do to help you? If the answer is no, you can't do anything because I can't get my insurance, well, that may end the discussion. But you should ask, how can I help? The obligation to interact, and we've talked about this, it is triggered when you know of the disability and there has been a reasonable accommodation request, even when that's ambiguous regarding the price, nature of the disability or the desire for accommodation. Because what? You can ask for that information. What you can't do is just ignore it. You also have an obligation, if you know or have reason to know, that the employee has workplace problems because of a disability. But this is a little bit different. You can ignore that at your peril. You just have to recognize that the employee still has a Privacy Act concern. So you may ask again, how can I help? The agency has an obligation, if you know or have reason to know, that the disability prevents the employee from requesting accommodation. You ignore that at your own peril. The obligation is met if you ask and the employee says, butt out, I don't need your help. I think the biggest problems arise when the employee doesn't really recognize or accept his or her disability and the problems arise in the workplace. That's where it becomes really dicey. And I'm not saying there's any fix-all to that, but that I think is where the conflict is greatest. Or, as Bob has said previously, when the supervisor himself or herself is exacerbating that type of disability, then things get a little bit more difficult. The agency request for information, you've got a document, and this is where you will see, this is the attachment 9, the other one was attachment 8. If you want a pretty clear template for requesting information, go to that Civil Rights Directive, and I've got that down there at the bottom. Look at that attachment 9. It lays out the request for information. And as Bob has stated previously, you can look at 5 CFR Part 339, that's the medical standard. It's got a wealth of information in there about the type of information that you can request, right? As long as you're making a good faith effort to understand the problem and to accommodate the disability, you're fine. Where the problems arise is when the agency is trying to mess with the employee and ask for information that goes far beyond what is necessary to understand the problem and to accommodate the disability. Now remember, under these circumstances, we're already talking about a person who's disabled, a person who arguably is qualified, because that's the circumstance then when it would compel us to request information or to engage in that discussion so that we can provide reasonable accommodation. You always have the right to ask for prognosis or diagnosis when that information is not initially provided. Recent case, 2013, Social Security Administration. In that case, the doctor said, sorry, employer, Social Security Administration, I'm not giving you my patient's information because of the Privacy Act, because of HIPAA. In that case, the EEOC said, well, but if the agency doesn't have that information and they've asked for it legitimately, and the employee or the healthcare provider refuses to supply that, the agency can't understand the problem fully. It really can't understand the limitations, and therefore is not well positioned to accommodate the disability. So that protects or shields the agency in that case. But just be aware that your request for information, although you should document it fully, you don't want to go beyond the scope of what you need to understand the problem and to accommodate the disability. That interactive process should be surgical in nature. You don't want to go too far. You certainly would never say, okay, give us all of your medical documentation. That, the courts and the EEOC would say, is too much. Don't need it. Now,
Gavin, this is Sherry. I would just interject that if you're at the point of requesting medical documentation, I would, appreciate if you give me a call and we can talk about, and I can even assist you in developing the letter to request that medical documentation from the employee.
Yes, absolutely. I apologize if my comments were interpreted to mean that you should ignore HR. Absolutely not. HR, and Sherry is absolutely right, HR is a very valuable resource in this process. And my sense is that the agency supervisors, certainly solicitor's office supervisors, would reach out to HR for that assistance. I'm only giving you kind of a general idea on where you want to look for that, in addition to certainly relying upon HR. And part of this, and I've got that on that third prong from the bottom, that third bullet. Remember that your goal here is to identify a reasonable accommodation, and there may be several of them in there. So if you're gathering information, you've talked to HR, you've presented that letter to the employee to identify the problem, to understand the disability. If there are a number of reasonable accommodations that are available, you get to select as the agency. The individual, and Bob had mentioned this previously, if the individual rejects it, then that then makes them unqualified for further reasonable accommodation. If you've identified a reasonable accommodation, or the individual has, and you've selected one, that ends the process if he or she rejects it. You have no further obligation to go forward. Okay, on the disclosure information, what about, and I mentioned this previously, what about those individuals who observe that interactive process resulting in reasonable accommodation? What do you do if somebody says, hey, how come that employee, that attorney, that IT specialist is treated more favorably than the others? The EEO position on that is that DOI may not disclose any decision to provide reasonable accommodation for an employee. I've given you the site on that. DOI may, however, reference legitimate business reasons and compliance with the law in saying that it has a policy of assisting any employee who encounters difficulties in the workplace. Many of those workplace issues encountered by employees are personal, and in such circumstances, DOI respects employee privacy. If you go beyond that, because that's kind of where EEOC is tolerant. Go beyond that, you do that at your own peril. And that's something, again, I think that you should talk with HR about in describing to those individuals in the workplace why one individual might be treated in a more preferential manner. You may have to provide it, just you can't violate the law by disclosing the existence, the need for a reasonable accommodation, or the existence of a disability. Leave issues. There is no set amount of leave required as a reasonable accommodation of the Rehab Act, and by that I mean FMLA's limit of 12 work weeks of leave in a 12-month period does not necessarily confine Rehab Act leave to the same duration. Your duration of leave can be controlled by the undue hardship analysis. And remember that FMLA's serious health condition is not the same as disability under the Rehab Act. So you provide leave under the statute, FMLA, Rehab Act, whatever it may be, that affords the greatest rights to the individual. But you have no obligation to grant leave indefinitely. Illustration 9. So an employee suffers a serious head injury, and the supervisor then receives a letter from the treating physician who explains that the employee's recovery period remains unknown at present, and the injuries are going to require months of rest. You know, we talked about in one of those earlier illustrations that type of sense. You could grant that for a period, but it might make better sense to determine whether the individual is qualified first, right? Can he or she perform the essential functions with or without reasonable accommodation? But leave might constitute reasonable accommodation that would allow the individual to perform those essential functions. But how much leave is necessary? It might make sense to go back to the supervisor, or excuse me, to go back to the healthcare provider, the physician, and ask for greater information about that. Because under this illustration, it's not clear how much is really necessary. The EEOC would say that if you were to grant, under these circumstances, some form of leave, you would have to hold the position open. Not every court is in agreement with that, but I give that to you for your assessment, because the courts and the EEOC don't always see things eye to eye. Courts are going to be, I think, a little bit more restrictive and narrow in their approach. The EEOC is going to be broader in their approach and protective of the employee. So the EEOC says, yeah, you have to leave that open. However, the EEOC is quick to say that indefinite leave may constitute an undue hardship. And that's, as you see there, the fact sheet that applies performance and conduct standards to employees with disabilities. What about reassignment as a reasonable accommodation? We can, as an agency, reassign individuals to a vacant funded position if it's available at the time. Again, you're working with HR on this. As long as the agency knows or anticipates it is open or will become vacant in a reasonable amount of time. And we do use this as an accommodation of last resort. The agency standards emphasize that this should be pursuant to a broad search, and the extent of the search is controlled solely by the undue hardship analysis. And the position should be similar in terms of pay, status, and location, but it may not be. It may be an inferior position. That may be the way in which it goes.
Yeah, and Gavin, I would just interject here too. You know, this would be another opportunity to interact with the employee to determine what types of positions they would be willing to accept, whether it's of the same pay grade, lower grade, same geographic area, and those are conversations that, you know, you would want to have with the employee to try and gather that information so we know what the scope of the search would be.
Right, absolutely, and I know that HR officials are very helpful in that area to interact with the employee and, of course, to conduct the search, to go out there and help.
So this is good. Let me just jump in just to say, not only is HR helpful, but I would say that they are mandatory. No solicitor's office supervisor should be delving into these issues without HR.
Well, there you have it. Strong words from Ed. So, I agree with that. I think that we just can't work without them. So, illustration 10. What about this circumstance? And this person may be requesting a reassignment. An attorney with Parkinson's disease works in a litigation range and finds the long hours and constant deadlines difficult to handle. And as a result, the attorney requests reassignment to a less demanding position. The employer, in this circumstance, has a vacancy for an attorney to draft policy directives, provide legal responses to inquiries from the field. The position, the duties which the attorney qualifies to perform, that's important, demands fewer hours and allows the appointee to control his or her workflow. Under those circumstances, this comes, again, from the EEOC. The EEOC would say, you got to reassign. If you have, and Parkinson's disease is qualified as a disability, you've got an individual who's disabled. He can perform the essential functions of the litigation branch, but he really needs a reassignment to continue working because of the problems he's experiencing or she's experiencing. If you've got a vacancy, which this example or illustration provides, there is no need for the attorney to compete. You simply reassign. Now, what happens if, under those circumstances, you go from a 14 to a 13, whatever that may be? That's possible. an agency can reassign to another position, even though it may not have the same pay rate. That's permissible. Now, if the agency, under other circumstances, non-disabled circumstances, would save pay, you've got to save pay here. If under other circumstances you don't save pay, no need to save pay. That's the way the EEOC looks at it. They would say, you can reassign, but the reassigned employee takes what he or she gets as a result of that reassignment. And it's not supposed to be punitive. It's just, hey, you put them wherever you can. So a little bit more on reassignment, consistent with what I just said. If no similar position exists, you may reassign the individual to a lower graded position without safe pay unless non-disabled employees receive safe pay in analogous circumstances. Reassignment is not available to applicants, obviously, but it is to probationary employees as long as they qualify for this position held or desired. Okay, scope of the reassignment. The agency is not required ever to promote an individual with a disability. So if you have a disability, if you're supervising someone with a disability, never an obligation to promote. The agency is not required to create a position for reassignment. And also there's generally no requirement to change the seniority system through the Barnett case decided back in 2002. The agency is not required to help an employee become qualified for a reassignment. Not required to lower performance standards in order to reassign. You're not required to waive qualifications for a reassigned position. But still, reassignment can be valuable as a last resort if the position that the person holds is just not working out. And in order to save them from what? Removal, disability retirement, which may not be desirable circumstances for them or anyone. It may be beneficial for all to simply reassign, put them in a different spot. Okay, the timing of the individualized assessment. So thus far, here's what we've done. We've gone through disability. We've gone through qualified individuals with disability. We've talked about the different types of reasonable accommodation, paying some particular attention to leave issues, to reassignment issues. Let's talk a little bit about the timing associated with individualized assessments and agency responses. Sherry and I have talked about the Civil Rights Directive, and it is somewhat clear, but also somewhat contradictory as to the timing that you have. And so I've laid this out, but I'm going to let Sherry interject if she so chooses, to recognize, used to be under 373 Department Manual 15, I think that's right. Used to be there was 5 days in which you had to forward an employee's request. That's now changed. It's 5 to 10 days. I think that what they're trying to do in the Office of Civil Rights is to give 10 days, but they've referenced through a flow chart the original 5 days. So I'll put it to you this way. And when you get, if anyone gets in the department a request, act expeditiously on that. 5 days, 10 days. 10 days would be a top end. And then the agency has between 10 and 15 days. Again, I would say maybe it's as many as 15 days, but it's a little contradictory. I think this is going to get cleared up by the Civil Rights Directive.
Yeah, and I have raised it up to, through my chains to my supervisor that there's some contradictions in the time frames, because I would lean more towards the time frames that are listed in the table, Table 1 of the Civil Rights Directive, because I think the flow chart was just brought over from the old department manual that's been superseded. So I would lean more towards the second number on the 10 and the 15. But as you said, we want to, if it's something that we can respond to in a day, we should respond to it in a day and not take the full 10 days. And those are business days, not calendar days.
Right, absolutely. And thanks, Sherry. And I agree. I think that Sherry's making a very good point there. You probably have the bigger time period, the 10 days, 15 days, but just be aware that there is some inconsistency there. If you need medical documentation, right, so the request comes in and you respond quickly to it. If you need medical documentation, you can request that, and then once the individual provides that, if he or she does, then you would have 10 business days to respond to that, and then you have 20 business days essentially to provide the accommodation after it's been
And typically in the request for medical documentation, what I have done is start out with 15 days to provide that medical documentation, and then with the provision that if they need more time, if the employee needs more time to get that they can request an extension. So just to give you an idea of how much time they actually have to provide that medical documentation, that's usually where I start.
Excellent. Thank you, Sherry. And for those of you who are out there, I know you're seeing we're going over a couple of minutes, but that's to give you the full 2 hours. I want to satisfy everybody's supervisory requirement, and because we were out there for the sheltering in place, I'm picking up the extra 10 minutes here. Okay, so there are also time frames in there for delayed implementation and for the reconsideration and appeal phases. Those exist as well. So again, I refer you to HR and also the Civil Rights Directive 2014-02. So all of that will be helpful in your understanding the time frame. But please recognize it's quick. You don't want to delay on any of this. Otherwise, problems arise. Okay, so refining the agency's response. You want to proceed expeditiously, as quickly as possible. You may require the individual to see an appropriate healthcare provider, and that includes an agency healthcare provider. The agency can do that, but first, you would have to, for example, if you believe that the individual requesting reasonable accommodation has supplied deficient information and you need addition, you would have to identify the deficiencies, give the employee an opportunity to cure on his or her own, right, going back to their own healthcare provider. And if that still is not possible, then the agency can pay for the employee to go to an appropriate healthcare provider. That's all possible. That's really a last resort, though. You want the individual to contact, communicate with their own healthcare provider. If the agency delays in responding, right, that may happen. You got to consider the reasons for the delay, the length of the delay, and how much the individual with the disability and the agency each contributed to the delay, what the agency was doing during the delay, and whether the accommodation was very simple or complex. And that comes from the Cobb-Hendricks case out of the EEOC. They'll give some latitude to the agency, but only if those delays are really attributed to the individual with the disability. If the agency is causing the delays without justification, it's going to be painful, and we don't want that. If we refuse to provide the reasonable accommodation based upon the undue hardship, we have to be basing that upon significant difficulties or expenses when considered in light of several factors. So if the individual is disabled, qualified, has asked for a reasonable accommodation, the agency says, sorry, we can't provide that. You can base that, sorry, we can't provide that analysis on the nature of the net cost. But cost is dangerous because cost under those circumstances is really tied not only to the overall financial resources of the agency, of the facility, but also of the agency itself. So you're opening up the agency's books, and obviously that's dangerous. Or we can base it upon the type of operation, the workforce composition. But really, I think the biggest issue here is basing, if need be, the undue hardship analysis on the impact of that accommodation on the operation of the facility, including the impact on other agency employees who perform duties at the facility. That's going to be the biggest issue. If that's a problem, then you want to base your undue hardship analysis on that. And once again, in communication, as Ed said, with Sherry and others in the HR shop, you may, with the HR officer, look at sample denial letters. And that's going to be found at attachment 7 of the Civil Rights Directive of 2014-02. That gives you, it's more or less a checkbox. You know, we're denying based on this, but there is going to have to be some substantive information. And Sherry or others in her office could assist in developing a full-blown letter if that is necessary. So be aware, if you're going to deny on undue hardship, it's dangerous to do so on financial resources alone, but maybe look carefully at the impact on other agency employees, and then you can deny on that basis. So here, for example, what about an employee who has sensitivity to light, seeks reasonable accommodation in the form of a darkened office space throughout the entire workday? But the employee works with a bunch of other employees and colleagues in an open area, and the supervisor then seeks your advice. How would you respond? That, you know, other than simply saying, okay, how can we help? We kind of got that. If the sensitivity to light does qualify as a disability, and the employee, save for the need for a darkened office space, can perform the essential functions, then the employee would be entitled to reasonable accommodation. But under these circumstances, it may be an undue hardship to provide what is requested. However, a solution might be what if we relocate your office space to an area that's much darker, closer to blinds that you can shut, things of that nature, or putting that person in a separate office space entirely to satisfy that person's need for a reasonable accommodation. Other solutions may exist too. Just recognize that there are many possibilities. You want to interact with the employee and document as you're doing it. And we've already talked about illustration 12, where the agency can pull back from a previously provided accommodation if things do not work. All right, we got through 72 slides. I want to talk briefly about the direct threat issues. You've heard Bob and Horace talk briefly about this. Direct threats come in the form of qualification standards. It's not really an essential function issue, but it's a qualification standard. You can say that an individual can't pose a direct threat. If that's the analysis employed, you want to analyze that in two steps. You establish that an individual is prevented from performing the duties or essential functions without a high probability of substantial harm, and that the agency cannot make reasonable accommodation without an undue hardship, so that the individual can perform the essential functions without significant risk. You cannot rely upon subjective perceptions, irrational fears, or stereotypes, and if you have medical standards, that's most helpful. You must evaluate the individual based upon several factors, including duration of the risk, the nature and severity of the harm, problem, the likelihood of potential harm that will occur, and the imminence of potential harm. Now, we have gotten through all 73, I believe, of the slides. I think the panel is happy to take any questions and respond to them, or if not, we will bring on.
Yeah.
Gavin, this is Sherry. I just had one more, I guess, general comment to throw out. There are some programs out there that if an employee needs like assistive technology or that we can explore that will sometimes pay for those accommodations. I also think that you probably have some funds set aside for like ergonomic desks to help field offices pay for those types of equipment. So if there is a question of being able to afford it at a local level, there may be some alternatives to assist in paying for equipment.
Great, and that's very helpful too, because the individual facility may not have the funds, and it would be risky to base an undue hardship analysis solely on that. So if we can broaden that pool of funds, that will be helpful. Anyone else who wants to comment, the panelists, or any questions that we have?
Well, this is Bob Garby. I'll just throw in that if anyone has questions about the medical documentation piece, what to ask for, how to interpret it, what constitutes a legitimate piece of medical information from a provider, they can always contact me or Kate Sawyer at the Departmental Safety and Health Office, and we'd be happy to kind of steer you through that.
And both of their addresses are readily available in the database. Find both. Any other panelists or any other questions that we've got?
Gavin, this is Shayla. Unless there are questions after I say this, which I'm totally happy to have them presented, I wanted to just say thank you very much to all of you who provided this. This is terrific training, very helpful, answered some long-standing questions I've had myself about these issues, and so I think this was really well worth the effort, and I appreciate it very much.
Gavin, this is Lori. I have to second that. Thank you so much. It was really a pleasure to work with everybody on this panel, and thank you for your time and effort.
All right. Well, thank you all.
Thank you.
Thanks, Gavin.
Bye-bye.